Good evening. Am I audible?
Yes, sir. Yes, sir. Yes, sir.
Okay, thank you.
Justice cannot be for one side alone, but must be for both, says Eleanor Roosevelt. A pleasant evening to one and all present here. With immense pride and anticipation, we welcome you all to the Kerala Law Academy Trial Advocacy Competition 2025, organized by Kerala Law Academy Law College in association with KLA Moot Court Society and IQSC KLA. Over the years, this competition has grown into a prestigious national platform, showcasing the intellect, composure, and advocacy skills of aspiring lawyers from across the country. It stands as a celebration of justice, reasoning, and the spirit of the courtroom.
Trial advocacy as an art that bridges the gap between theory and practice. It allows budding lawyers to experience the essence of litigation, preparation strategy, and persuasion before they step into real courtrooms. The Kerala Law Academy Law College, established in 1966 by the legal luminary late Dr. N. Narayan sir, has consistently been a center of excellence in legal education, research, and reforms. Its commitment to quality learning continues to empower students to become advocates of justice and integrity. The Kerala Law Academy stands apart as the only institution in the country that proudly hosts 5 national and international competitions every year, an enduring testament to its commitment to academic excellence and global engagement. The Kerala Law Academy Law College Trial Advocacy Competition 2025 continues this proud legacy, bringing together the best young legal minds to test their skills and spirit in simulated courtrooms.
Today, we celebrate the spirit of student initiative, the energy, the creativity, and perseverance that have brought this event to life. We have prepared a short virtual montage to give you a glimpse into the vibrant life at Kerala Law Academy and the legacy of our trial advocacy competition. Let's take a moment to view it.
The Kerala Law Academy Law College is proud to host the 6th Kerala Law Academy Trial Advocacy Competition at the national level, scheduled from 10th to 12th October 2025. This prestigious event is organized in collaboration with the KLA Moot Court Society, the KLA Trial Advocacy Forum, and the Internal Quality Assurance Cell IQAC of the Academy. Trial advocacy is not merely a competition, it's a celebration of legal intellect, courtroom strategy, and the spirit of justice. It brings together some of the brightest law students from across the country to engage in simulated criminal trials, showcasing their advocacy skills and legal acumen.
Kerala Law Academy Law College, established in 1966, stands as a beacon of legal education in India. It is the first private law college in Kerala, and over a decade, it has carved a niche for itself, a center of academic excellence, professional integrity, and social commitment. Affiliated to University of Kerala and recognized by Bar Council of India, the Academy consistently produced generation of successful lawyers, academicians, and legal consultants. Its alumni has gone on to serve in prestigious positions across judiciary, corporate sector, and international legal forum.
The institution's legacy is deeply rooted in the visionary leadership of its founder, Dr. N. Narayan sir, whose dedication to legal empowerment and academic rigor laid the foundation for what the college is today. With a sprawling campus in Perurkada, Thiruvananthapuram, the college offers a dynamic learning environment, blending traditional legal instruction with modern pedagogical tools. Its emphasis on clinical legal education, moot court training, legal aid programs, and trial simulations ensure that students graduate not only with theoretical knowledge but also with practical skills essential for the legal profession. Kerala Law Academy is not only known for its competitions but also for its international academic outreach. Each year, the Academy conducts 5 international seminars, bringing together scholars, practitioners, and students from around the world. These seminars cover diverse themes such as human rights, environmental law, cyber law, constitutional governance, and global justice systems. They serve as platforms for interdisciplinary dialogue, comparative legal analysis, and collaborative research, reinforcing the Academy's role as a global thought leader in legal education.
Kerala Law Academy organizes 5 major legal competitions annually: the International Mediation Competition, the All India Moot Court Competition, the Alternative Dispute Resolution Competition, the Client Consulting Competition, and the Trial Advocacy Competition. Each of these events attract participants from across India and abroad, fostering a vibrant exchange of idea, legal culture, and advocacy style. The Academy's ability to execute these events with precision and professionalism reflects its unwavering commitment to nurturing legal excellence.
Beyond academics and competitions, Kerala Law Academy fosters a culture of social responsibility and legal activism. Through its Legal Aid Clinic, Human Rights Cell, NSS, NCC, Anti-Drugs Awareness Program, Community Outreach Program, students are encouraged to engage with real-world legal challenges and contribute meaningfully to the society. The Academy believes that law is not just a profession, it is a tool for transformation, and every student must be equipped to use it for the greater good.
Trial advocacy as a discipline is the art and science of presenting a case before a court. It involves mastering the techniques of opening statement, direct and cross-examination, evidence presentation, and closing arguments. This competition is designed to stimulate real courtroom proceedings, allowing the students to step into the shoes of litigators, witnesses, and judges. Participants are trained to present a complete criminal trial run within a span of 1 hour, a process that in real court which may take years. This condensed format challenges students to think critically, act swiftly, and argue persuasively.
The Trial Advocacy Forum of KLU plays a pivotal role in mentoring students, curating case materials, and designing realistic trial scenarios. This year's competition focuses on criminal law and commercial disputes, offering participants a chance to engage with complex legal issues and develop courtroom strategies. Through this forum, students gain exposure to real-world litigation, evidence handling, and procedural law, skills that are indispensable for any aspiring trial lawyer.
The skills taught through trial advocacy are divided into 2 broad categories: tactical skills such as jury selection, witness examination, and argument delivery; strategic skills, which involves integrating these actions to shape the narrative and influence the outcome. While many law schools focus on tactical training, Kerala Law Academy goes a step further by introducing strategic planning and ethical reasoning into its curriculum. The holistic approach ensures that the students are not just skilled performers but throughout advocates who understand the deeper responsibility of legal practice.
The Trial Advocacy Competition also serves a broader purpose: to democratize legal education and bridge systematic gaps. Advanced strategic techniques, though sometimes debated, are essential tools for leveling the playing fields, especially in cases where indigent defense face well-resourced prosecution teams. By teaching these methods, the Academy empowers students to become advocates to justice, capable of defending the rights of marginalized and challenging institutional inequalities.
Trial advocacy also cultivates the human side of law: empathy, clarity, and conviction. It teaches students to learn, to reason, to respond with integrity. In every simulated trial, they learn not just how to win a case, but how to uphold the values of fairness and due process. The competition is a reminder that behind every argument lies a story, behind every verdict, a life.
As you stand on the threshold of the exciting journey, we invite each one of you, participants, dignitaries, faculties, and guests, to be part of this transformative experience. This competition is more than a contest. It is a platform for growth, learning, and excellence. Let the courtroom come alive with your arguments, let justice echo through your words, and let the spirit of advocacy shine through every trial.
As the final gravel prepares to fall, we celebrate not just the brilliance of argument, but the discipline of preparation, the courage of convention, and the pursuits of justice. The 6th Kerala Law Academy Trial Court Competition is a tribute to every student who dares to think, speak, and advocate with purpose. Let this experience shape your voice, sharpen your vision, and strengthen your resolve. Thank you.
That was truly inspiring. As the saying goes, coming together is a beginning, keeping together is progress, and working together is success. To formally commence the session, we are honored to have with us Sri Anil Kumar Ji sir, Vice Principal, the Kerala Law Academy Law College, a constant source of motivation and support to all our academic and co-curricular activities. His steady guidance, approachable leadership, and unwavering encouragement have played a vital role in shaping the vibrant learning environment that we cherish today. We are truly grateful for his presence and continued commitment to nurturing excellence within the academy. I invite Sir to deliver the welcome address. Sir, please.
Thank you. Esteemed Professor Dr. Vivekanandan Sir, Vice Chancellor, Hidayatullah National Law University, Raipur, Advocate Nagaraj Narayan Sir, Director, Kerala Law Academy Law College, and Member, Bar Council of Kerala, Professor Anil Kumar K. Sir, Director, Administration, Students and Faculty Affairs, Kerala Law Academy Law College, respected faculty members, distinguished guests, participants, and members of the legal fraternity. It gives me immense joy and pride to extend a warm and heartfelt welcome to each one of you to the inaugural session of the 6th National Trial Advocacy Competition 2025, organized by Kerala Law Academy Law College in association with Kerala Law Academy Moot Court Society and IQSC KLA. The trial advocacy competition is far more than a contest. It is a rigorous simulation of courtroom practice, a dynamic training ground where aspiring litigators refine the craft of legal persuasion. Here, students step into the role of counsel, witnesses, judges, and navigating the intricacies of criminal procedure, evidence, and strategic argumentation. This platform bridges the divide between textbook theory and courtroom reality, sharpening analytical thinking, reinforcing ethical conduct, and cultivation of the advocacy skills essential to the legal profession. For every future trial lawyer, these experiences are foundational in championing justice through precision, preparation, and principled advocacy. We are truly honored to have with us today the luminary of legal fraternity whose presence lends immense prestige to this occasion. His experience, scholarship, and professional journey serves as a beacon of inspiration for all of us gathered here. It is our distinct honor and privilege to welcome Professor Dr. V.C. Vivekanandan Sir, Vice Chancellor of Hidayatullah National Law University, to this prestigious occasion. Sir is a towering figure in Indian legal academia with over 3 decades of teaching, research, and institutional leadership. His journey spans some of the most respected institutions in the country, including NLISU Bangalore, Nalsar Hyderabad, and IIT Kharagpur, where he served as Dean of the Rajiv Gandhi School of Intellectual Property Law. He was also the founding Dean of the School of Law at Bennett University, Greater Noida. His academic credentials are equally remarkable, holding a bachelor's, master's, and PhD in law, along with the master's and MPhil in public administration. His interdisciplinary expertise has shaped innovative legal curricula and inspired generations of law students. Sir's contributions extend far beyond the classroom. He was appointed as the MHRD Chair Professor and served as an official delegate representing the Government of India at international negotiations in Geneva. He has played a key role in global legal forums such as ICANN, where he represented the Asia-Pacific region and later served on its nomination committee. He is also the founder director of the Legal Information Institute of India, a pioneering initiative under the Free Access to Law movement, and has held fellowships and visiting scholar positions at Manchester University, Tokyo's Institute of Intellectual Property, and Sunny Buffalo Business School. We are truly privileged to have with him today. His presence lends immense prestige to this event, and his words will undoubtedly inspire every participant gathered here. I welcome you to this function, sir. Next is our immense pleasure to welcome Advocate Nagaraj Narayanan sir, Director of Kerala Law Academy Law College and Member Bar Council of Kerala. Sir stands as the unshakable pillar of our institution, a guiding force whose dedication to academic excellence and commitment to student welfare inspire everyone at KLA. His vision and leadership have continuously elevated the standards of our college. We extend our heartfelt gratitude and warmest welcome to you, sir. We also extend a very warm welcome to Professor Anil Kumar K. Sir, Director of Administration, Students and Faculty Affairs. Sir's dynamism and forward-thinking leadership have propelled countless initiatives that enriched the academic culture of our college. His deep understanding of evolving educational paradigms and unwavering commitment to student development make him an invaluable strength to our institution. Sir, we are truly privileged to have your presence with us today. A sincere and profound thanks goes to our treasured and cherished principal, Professor Harindran K. Sir, whose unwavering commitment to academic excellence and institutional growth has always been the backbone of this college. Sir, you have always extended your full support to all our academic and extracurricular initiatives. On behalf of the Kerala Law Academy and on my own behalf, thank you, sir. We are truly grateful. We are also delighted to welcome Professor Dr. Ajita Nayarel, Head of the Department, who has been an integral part of the Kerala Law Academy family for more than 25 years. Ma'am's long and dedicated service, marked by academic brilliance and compassionate mentorship, continues to inspire both students and colleagues alike. Ma'am, we are deeply honored to have you with us. Our heartfelt welcome also goes to Dr. Dakshana Saraswati, Associate Professor and General Secretary of Kerala Law Academy Moot Court Society. Ma'am's guidance and organizational expertise have been instrumental in shaping this event. Her tireless dedication, precision, and vision have transformed this competition into a benchmark of excellence. Ma'am, we extend our deepest appreciation and warmest welcome. We would also like to warmly welcome our faculty conveners, Shalini AP, Mrs. Radhika RP, Dr. Malavika J, Mrs. Akhila CM, Mrs. Alaga SI, and Mrs. Celine G. Your constant support, planning, and coordination have made this event possible. Your commitment to nurturing the next generation of legal professionals deserves heartfelt recognition. A very warm welcome to the dedicated team of the Kerala Law Academy Moot Court Society, whose tireless efforts have been instrumental in bringing this event to life. Your meticulous coordination and behind-the-scenes commitment have been central to the smooth and successful conduct of today's inaugural session. My deep appreciation goes to Arjun Sunil and Aishwarya Tulasi, General Student Conveners of Moot Court Society Kerala Law Academy, and my appreciation also goes to Student Conveners Gauri C, Iron Elsa Charian, Anandan, Jodi, Nidhi, Prarthana Karma, Jaya Gobiga, Ajit Darshan. Your teamwork, enthusiasm, and diligence have been the backbone of this competition success. A warm as well as to welcome to the anchors of today's session, Mrs. Aishwarya Tulasi and Mrs. Iron Elsa Charian. Your dedication and presence add grace and energy to this inaugural function. And finally, a special word of welcome to all our participants joining us from across India. Your enthusiasm and participation truly make this competition a national forum for learning and dialogue. May this competition serve as a catalyst for meaningful learning, professional growth, and lasting connections. Thank you, and let us embrace the journey ahead with enthusiasm and purpose.
Thank you so much, sir, for your kind words of welcome. Today, we are privileged to have in our midst an eminent academician and visionary leader, Professor Dr. Vivekanandan sir, Vice Chancellor, Hidayatullah National Law University, Raipur, to this prestigious occasion. With over 3 decades of experience in legal education, he has served at NLSIU Bangalore, Nalsar Hyderabad, and IIT Kharagpur, and was the founding dean of Bennett University School of Law. He has represented India in international negotiations at Geneva, contributed to global legal forums such as ICANN, and pioneered initiatives like the Legal Information Institute of India. His academic leadership and policy engagement continue to shape the future of legal education. Sir, we are honored to have you with us, and with great pleasure, I invite Professor Dr. Vivekanandan sir to deliver the inaugural address. Sir, please.
Thank you very much, and I hope I'm audible the other side. All right, thank you. So, Sri Nagaraj Narayanan, eminent lawyer and director of Kerala Law Academy Law College, Professor Anil Kumar, Vice Principal, Kerala Law Academy Law College, Professor Dakshina Saraswati, who has invited me for this program today, distinguished faculties and students of Kerala Law Academy and participants in this event from all over the country. I would like to give my warm greetings to all of you. It's a pleasure and privilege to be invited for this important event and would like to thank the organizers. I personally believe participating virtually in Kerala is not a good idea, right? Kerala has to be physically visited, and that's the dream of people all over the world as a tourist destination. But as due to contingency and many things, we are settling for a virtual talk. I'm pretty sure that sooner or later that I will have an opportunity to be around to meet all of you in the academy. With this, I would like to say a few aspects today. In the beginning, I would like to say very important of the exercise of trial advocacy. Its core point of many of these things in an open society and a democracy is a word called liberty. And when you say the word liberty, it's a simple word, has many connotations, at times misinterpretations. But nevertheless, the word liberty is one which is the most cherished thing which law tries to constantly establish. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can even do much to help it. These are not my words. These are the words in a celebrated lecture called The Spirit of Liberty, given by a judge in US called Learned Hand, his name, in 1944, in a celebratory speech, which is called I Am an American Day. It's called as I Am an American Day, where liberty is the central thing of one of the oldest democracy in the world. We are the largest democracy in the world. And if I had to tell, very simple liberty in a different way was interpreted by our own iconic justice, a world famous Justice V.R. Krishna Iyer, who said the basic rule is bail, not jail. So this has to reverberate when we are really talking about trial advocacy. As I said, this competition, as I saw your multimedia clip, which more effectively talked about how it bridges the gap between theoretical classroom learning and the real world courtroom experience. This simulated trials, students learn, analyze facts, hone their argumentative skills. They know how to examine witnesses and also apply procedural and evidentiary laws. So this is basically cultivated in legal education institutions, and this type of competition really serves the intended purpose of how they come out from the classroom to the courtroom and try to put their theory into practice. Quite often, there is a misnomer that theory and practice are not interrelated. In fact, theory and practice are very much interconnected. But theory and practice, by nature, will have a gap. Any type of theory and practice will have a gap because theory is a condensation of past experience. and trying to put it conceptually and train people. Practice is a dynamic thing which keeps happening in present and future. So what is happening in present and future gets condensed as theory, and by the time the present and future keeps changing. So naturally, you will have what I call a chasm between the theory as well as practice. And what do we do with that is simple. It is not one at the cost of another. It is both having a strong theoretical foundation as well as gearing towards what is the practical way of solving things. And this is where your entire exercise of trial advocacy assumes a great importance. And when they say trial advocacy, that even though there are many, many subjects, I would rather say trial advocacy very closely, can be connected with the criminal justice administration system. So if I have to spend a little time, which I thought more relevant for the students here today and also other colleagues, is about kind of change what is happening in the country's landscape. That is the new 3 laws which has come, replacing even the nomenclature, which was more British and more Western and more English to more Indian style of nomenclature. The Bharatiya Nyaya Sanhita, BNS, the Bharatiya Nagarik Suraksha Sanhita, BNSS, and Bharatiya Sakshya Adhinayam, BSA. And these three. The question normally before even this came is, people said whether is it a old wine in a new bottle, or is it a new wine in a new bottle? People started a lot of commentary. And there was also a lot of criticism that we should have given enough time to discuss, condense, and do that. But in real life, again, theoretically speaking, these are all right. But when you talk about practice for a lawyer, how much time a lawyer theoretically can spend before going to the courtroom? I think any lawyer who's practicing will guess literally no time. Literally, you're adjusting things. Literally, you're hitting the road and running. So it's so one way that this has been quite some time in a cold storage, right? And then it has come out naturally when it came out an year before, when this was almost now it celebrated the first birthday or anniversary of these 3 laws. It was brought in at some level, and people said as we practice and we roll out with the help of many stakeholders, including judiciary, we'll be able to fine tune. As Henry Ford, all of you know, who's considered as the pioneer in automobile industry in America in the early 1900, 1903, 1904, he announced to the American public, his dream is to get one car for every American family. Those times, no cars were there. Very few, were just, driven by the rich and powerful. When he said for every American there is a car, people laughed because in 1900, America was terrible in terms of roads, cobblestones. It was horse-driven carriages. Everywhere the horse dung was there, not cleaned, ethanol smell and many things going. It's a terrible roads. So when people laughed and said, you're talking about a car for every American when the roads are so terrible. So Henry Ford made on counter. He said, when good cars come, good roads will come, not the other way, he said. It's not that you will make good roads and then good cars can be manufactured. You make good cars, people love to maintain those good cars, so they will demand better roads and probably roads will come. So in a way, we have to take sometimes that when the laws do kick in and run around, probably what you call as things will be in place. And that is how we are seeing this 1 year agreement. But if I want to touch upon for the young people here on this, especially who are concentrating on criminal law, I would like to put few headline shifts. I call that as headline shifts. First is the key way we look at things. Sedition, we all know, a huge British legacy, the word sedition, against the mighty empire, the mighty king and queen. It is called sedition. Sedition is now out, whereas sovereignty offense is inside. Section 124A IPC talked about sedition, and instead of that, in BNS 152, it penalizes acts endangering the sovereignty, unity, and integrity of India, which covering speech, signs, or electronic communication, or financing of secession and armed rebellion. One may say that it's in the same thing. No, there's a big difference in terms of the nomenclature of words, because sovereignty is much more rooted in terms of independence and democracy. So they felt that we need to give a very, very positive spin of what we are doing, not just the word sedition, which was coined, which was used, which was practiced mostly against when there's a foreign power. Whereas when we talk sovereignty, we are talking about we the people. Second, it also brought in the headlines that new offenses. The government official explainer of normally ads for terrorist acts, mob lynching, snatching, organized and petty organized crime, among other things. Mob lynching, especially, appears as a specific aggravated homicide, while making snatching is separated from theft and robbery. These changes are meant to reflect contemporary harm patterns. This mob lynching, maybe you never heard few decades back. Of course, it was there, mob lynchings were there in the heights of partition tension in the country, right? After that, we never heard about lynchings much on the headlines, maybe occasionally here and there. But it is now getting so frequented, they thought it's high time, categorize that as a new offense. And also snatching, which is again a phenomenon last few decades. You know that every day, you're reporting about snatching. So is it from theft and robbery? They want to give a very nuanced new offense on this. Also, this little, what I call as obfuscated term called community service. So BNS explicitly lists community service as a punishment for select minor offenses, a move to decongest prisons and also to tailor proportional sanctions. I distinctly remember few decades back, right, in Tamil Nadu, in one of the case, a person was convicted and he was quite defiantly trying to justify, because he said, my conscience said what I was right, I did that. So the judge realized this man seems to be have taken in his mind a wrong thing as a right thing. So how do I really change him? Even after conviction, when he comes out, he's going to go with that particular conviction in his mind. So what he interestingly told was, he has to spend 1 week in a library in Gandhi Gram University in Madurai. Books. He said, you have to sit there 1 week, you have to read and write notes and submit. I'm reducing your imprisonment based on that. I think he happily thought, good, I'm going to get a reduction. After all, sitting in a nice library and reading, and I will come back and then escape. But eventually, after he comes out of a week, he was pleading with the judge that, sir, you can keep my thing some more time, it doesn't matter. Can I be permitted another few weeks to sit in the library and do? Because this man started reading. Suddenly, whatever advice his mother gave or judge gave, he did not realize. But reading those books, it completely changes. And it's an interesting community service. It is a real community service where it is not shaming or anyone, but trying them to allow peacefully to, introspect oneself and do. And whether it will work or not, we never given a trial to this. And this, interestingly, they have concentrated that what is a community service and how far we can do that, especially for minor offenses. And also the preliminary inquiry, modifying the preliminary inquiry before registering an FIR is now a very narrow band of cases where it is punishment less than 3 years or less than 7 years with a 14-day limit. It's an attempt to reconcile in Lalita Kumari's FIR case, mandated with practical screening. So this was again something thought which has been pending more as a talk shop, but they want to bring it as part of the law. And then under trial detention cap, Section 479. It caps pre-trial incarceration relative to the maximum sentence. The Supreme Court has applied this provision expansively in the past. So they have brought it instead of every time a court and then gets into analysis and then comes case by case, and there could be differential approach between judges. So they thought it's better to bring down into the law, and that was Section 479. Most importantly, all of us are living in the digital age, and all of us are connected. 200 plus people all over the country, and we are all talking to each other just at the real time. And so we are in the digital age. It is not some exquisite or exotic thing. It's a very, very ordinary, common thing where families across India make it a point to have a Zoom meeting or some other platform meeting. So BNSS really enables e-FIRs and e-summons, AV recorded statements, and remote testimony. States are building the pipes, forensics, video links, mobile labs, how to operationalize. Again, I saw a criticism. Oh, where is the money for this, for stations? What will happen? As pointed out, for every new thing which you bring in, there could be 100 hurdles. 100 hurdles. But the point is very simple. You have to make a beginning and things will fall in place, at least compared to a few years before. I think all of us were more free, got into this online thanks to this uninvited pandemic. And at that time, we all know we did not know to operate, and things were not so clear, and all kinds of issues. I think our success rate today in terms of online transactions of these type of things or witnesses, many things, is tremendously high. And so the digital procedure has been strongly put in, and then it is being operated under the new BNSS. Then the evidence thing also recognizes digital records, even though it is little old when the IT Act came and it was stuck somewhere in the provision. Only few people who knew cyber law understood, but now they have made it much more clearer and clarified what is authenticity, what is the chain of custody pathways in a tech neutral fashion. And that is again the problem. As I said, technology, once upon a time, people used to have this old saying, technology is neither good nor bad. Technology is neither good nor bad. Then somebody else added, technology is neither good nor bad and also not neutral, which means there can be something inbuilt in technology. Lawrence Lessig, one of these top professors of IP, used to wrote the book 2 decades before called The Code, CODE. Every law student should read it. The book name is called Code, CODE. He wrote it, I'm talking about 20 years back. What he said, many of the things are going to be decided by the code written by an engineer. And that code is becoming your life. And everything will be within the code. So very interestingly, whether technology is neutral, that is very, very important. The debate whether technology to be there or not is gone. I don't think anybody is going to even think in their wildest dream technology should be there or not. But the point is technology makes you believe what they call you can have an hallucination through technology, thinking everything is correct, but it's not correct. So this is where you call tech neutral fashion. And then, so these are some of the headline shift, I would say that. So it is a critical analysis where I said about technology. But what is the flip side of people who are wary about some of these things or where things can go wrong? That is quite crucial. in my opinion, if I put it that first, when I said the word sovereignty, from sedition to sovereignty, then the question is there a clarity or does it have a overreach risk? Replacing sedition in BNS 152 was framed as a decolonizing the code while safeguarding national security. The text sweeps in acts done, quote unquote, purposefully or knowingly, that excite or attempt to excite secession, armed rebellion. Now, the critics are worried about what is the vagueness about how do I really define purposefully? Who decides something is purposefully? Who decides knowingly? And this could have a potential chilling effect. And mens rea proof under the digital age speech is a very difficult proposition than pre-digital age. So proponents say this section narrows down colonial phrasing and anchors culpability in demonstrable intent and concrete harms to integrity. So you expect in coming days, it's just a year, you will expect constitutional scrutiny will happen on what is called precision, what is called proportionality, and what is called necessity. So precision, proportionality, and necessity tests will be a very important part under Article 14, 19, 21 of the Indian Constitution, where they will analyze how BNSS is going to be played out. So, as you said, everybody welcome BNSS, but at the same time, they're going to look how far it is going to be operated and where some unknowing pitfalls might come. Also, I talked about what we call as mob lynching, snatching, and organized crime earlier as a headline shift. But if I really look at the distinct offenses of mob lynching and snatching, signals a problem. What is the problem is it is basically data-driven policing and sentencing calibration. The policy upside is visibility and consistency, but on the downside is overlap with homicide robbery provisions, risking what they call charge stacking, they call it, or uneven invocation across states. The implementation quality, the standard operating procedure, the training, the charge framing, the way you do all this will decide if these provisions reduce impunity or is it going to simply relabel existing crimes. So this is again lawyers, law teachers, legal researchers, jurists in the court will be looking. And I did mention about community service and penal rationality and give you illustration. So BNS's embrace of community service offers proportionality, reparation, and social utility for minor things on the theory. On the practice side, it aligns with global restorative trends and reduces the overuse. The practical challenge is, will there be a standardized assessment of suitability? Will it be a meaningful assignment design or monitoring compliance or avoiding socio-economic bias? Which is, end of the day, when I say this, whatever you bring in new concepts, technology backup, it's human beings. And human beings have sometimes open as well as hidden bias. So the socio-economic bias is very, very, very difficult to, come out of certain things. So how do you think when it is the humans who are going to decide about what is this kind of penal rationality? Will they have differential yardsticks, differential set of things? And this is a job to be empirically studied as we proceed in many cases what will come. And this I want to emphasize in trial advocacy as well as everything. Law people generally, I find in my long years of teaching and research experience, we are very allergic to empirical studies. Every second, third thesis I see, it says jurisprudential. Because jurisprudential sometimes is the best cover, where you can just have some vague words and get away. Whereas when I say empirical, right, it is very, very difficult, and it needs time, it needs precision, it needs statistics, it needs sampling, many things, and probably empiricism will really bring out more rationality in terms of criminal justice administration system. Jurisprudential is nice, philosophical, it has its value, but you start to end, you talking about a jurisprudential approach, you are really missing the trees for the woods, what they call. So this is important. And as the last point, which I said, is about timelines of the preliminary inquiry, which this particular new laws are bringing in, was speed with safeguards. Now it codifies preliminary inquiry in a limited band of offences, that is called 15-day cap. This aims to curb mechanical FIRs and reduce frivolous criminalization. But tensions remains with the case of Lalit Kumari and the risk that preliminary inquiry morphs into a threshold barrier. The Supreme Court has already, in last 1 year, have started drawing the guardrails against safeguarding these kind of things which BNSS might come. If you're reading the headlines every day in Supreme Court or High Court, they are also applying these new laws. And so they are many times wondering what to be done. And not to forget about the digitization, which I said, EFIRs and AV recorded evidence, as I said, it can cut delay and bolster audit trails. But at the same time, the different states, maybe southern states are slightly better in terms, relatively better to the northern states' counterparts in digitization. But even within southern states, you will find differential way how this is being rolled out. So you will have some kind of a different digital justice happening in parts. Again, within a state, the urban and districts, rural, are not even in such case. So it again requires, if this has to succeed, cyber forensic staffing is very, very crucial across the board in districts, and chain of custody, standard operating procedures, and also to how to secure storage standards. Because remember, like your physical paper, it takes long time to get destroyed, but digital also has a shelf life. It can get destroyed. So a lot of storage related matters. Otherwise, there may be nothing available sometimes when digital things gets completely spoiled. So these are some of the issues which are coming. So I would wrap up with 5 important case developments, which is very important for anybody who is in trial advocacy dealing with different things. As I said, at least if you look at citations to Supreme Court roundups, one is the first case about inhuman conditions in prisons versus DG prisons, right? In this case, the Supreme Court held that BNSS 479 maximum period of detention for under trials, and it applies retrospectively to under trials even if it's registered cases before the new law took effect. This reading makes Section 479 a system-wide relief valve for crowded prisons and entrenched delay. So this is one of the things which happened in July 2024, right? Before that, also cases apply. That's what the Supreme interpretation, which it was widely welcomed by human rights activists as well as people who are bothered about crowded prisons. The second one, PMLA. The cap extended to special laws like PMLA, where in the case of Badshah Majid Malik versus Director of Enforcement, decided on 18th October 2024, the Supreme Court granted a bail in PMLA case applying BNSS 479(1) provision, that is, bail after serving 1/3 of the maximum sentence, and signaling that BNSS under trial protection travels with prosecution under special statutes before special courts. That was again a positive spin-off of BNSS in that case. And the third case is Kushal Kumar Agarwal versus Enforcement Directorate in 2025. The court squashed A special court's cognizance order for want of an opportunity to the accused mandated by BNSS Section 2231, a procedural safeguard which was originally absent in CRPC. It reaffirmed that complaints under PMLA are governed by BNSS Chapter 16 after July 1st, 2024. And the next case, which is of importance to be shared with you, is how SC resolved the riddle in the case of Imran Pratap Gadi versus State of Gujarat in 2025. The court explained the difference between CRPC 154 and BNSS 173 and clarified how the preliminary inquiry meshes with Lalit Kumari case. It also articulated a reasonable person standard when assessing speech-based offenses like BNSS 196, that is called promoting enmity, warning against judging words through the lens of the insecure. It's a very interesting concept. Judging the words through the lens of an insecure, of the insecure. So they said that this is a correctional thing which they said, they squashed it. Earlier, they used some of the BNSS, some of the courts are doing this. So, and finally, the custody window, 15 days to be within first 40 days. In Hyder Ali versus State of Karnataka in 2024, affirming a Karnataka High Court ruling, the Supreme Court held that for offences punishable up to 10 years, the police custody maximum 15 days must be stored within the first 40 days under the BNSS 187, which is a textually driven tweak to the legacy remand practice. So I just listed 1 year. It's too early about what's happening in criminal justice system, which people involved in trial advocacy should be aware of. So these changes are meant. What are the changes for police, bar, bench, and academia? For police and prosecution, charging strategy must evolve. Digitized workflows needs to be practiced. Third, custody and under trial audits. You should have the kind of triggers expected, and then they should act upon it. Whereas in the defense side of the bar, new bail levers have come. Precognizance of hearing rights has been introduced, and preliminary inquiry scrutiny is an important thing for people who are defending the rights in the bar. Whereas for the judiciary, it is doctrinal calibration, that is early Supreme Court guidance in setting the guardrails of future action by the state or enforcement, and also transitional cases. That is very important. As far as legal academia like me and other teachers here measure the decolonization claim, which I told you earlier, empirical work should track whether the new offenses and the punishments are changing outcomes. Is it having an impact on conviction rates? Is it having an impact on length of sentences? And also, what is the status of under trial population? And also find out whether it's only a reframing of the label or there is a real impact. Second important for legal academia is the civil liberties impact, which I started my initial comment on the word liberty. So the civil liberties impact is and the only thing which sustains democracy. And anything, democracy slides slowly and steadily without we noticing it into a different form of governance if liberty is slowly and steadily compromised. If liberty is for some other distant person, we consider that it's not our job. Slowly, when it comes to your neighbor and slowly it knocks your door, right, then you realize that it is a point of no return. So it is very important, the civil liberties thing. So litigation watch academia should do, and also reliability on digital evidence and how it is going to play out can be really analyzed by the academia. As I said, it needs a healthy dose of empirical research. Without that to do, it is academia should encourage students to have some component of empiricism, which allows them to go to the field, to meet. After all, the best lawyers come out of interacting with society, and empirical things can be part of our, projects. Empirical thing can be part of some of the special things in our academia. So, as a closing synthesis, I would say that the Indian criminal law has been reset, not just as a new reordered chapters. Probably it is attempting to process discipline in terms of timelines, in terms of cap on under trial detention, in terms of structured pre-FIR screening. And also, it is not digital by design. As I said, FIRs, AV recordings, etc. In substance, these new laws, which are going to be very crucial part of criminal justice administration system, and your entire trial advocacy has a lot of impact and bearing on what is happening on criminal justice system. It is going to recognize what the modern harms and how to do. So the big question for the next couple of years is going to be which are the sections which will survive constitutional scrutiny, right? Which are the states who are going to operationalize e-process and digital evidence, and does new definitions improve conviction quality or bring in deterrence, or simply will it do that? So I would like to end again, as court reminded repeatedly, bail is the rule and criminal law must guard liberty even if it punishes crime. The new courts give India a modern toolkit. Their success will depend on how the tools are used by the police, by the prosecutors, and by judges, and how academia as a watchdog is going to play its role in terms of teaching students as well as publishing and researching on these things, which will bring in constitutional fairness, right? So this will be my kind of pointers which I want to share with the lot of enthusiastic people who are into the trial advocacy competition. So I once again thank as well as the organizers for giving me an opportunity to interact with a wide section of students as well as faculty through this event. Thank you very much.
Thank you, sir. Thank you very much for your inspiring words and valuable insights. We are truly grateful for your time and presence today. To express our heartfelt gratitude, we now invite Shakti Prabha M. Sir, Assistant Professor, the Kerala Law Academy Law College, to deliver the vote of thanks. Sir has always been a guiding force behind our academic and co-curricular endeavors. His quiet dedication, thoughtful mentorship, and unwavering support have helped us shape the success of this event and many others. We are truly grateful for his presence and leadership. Sir, please.
Thank you, Aishwarya. Esteemed Professor Dr. Vivekanandan Sir, Vice Chancellor of Hidayatullah National Law University, Raipur, Advocate Nagaraj Narayanan Sir, Director of Kerala Law Academy Law College and Member Bar Council of Kerala, Professor Anil Kumar K. Sir, Director of Administration, Students and Faculty Affairs, Kerala Law Academy Law College, respected faculty members, distinguished guests, participants, and members of legal fraternity. As we come to close of the inspiring inaugural session of the 6th National Trial Advocacy Competition 2025, organized by Kerala Law Academy Law College in association with the Kerala Law Academy Moot Court Society and IQAC KLA, it is my privilege on behalf of Kerala Law Academy Law College to extend our heartfelt gratitude to all of those who have made this day truly memorable. First and foremost, I extend our deepest gratitude to our Chief Guest, Professor Dr. V.C. Vivekanandan Sir, Honorable Vice Chancellor of Hidayatullah National Law University, Raipur. Sir, your remarkable journey as an academician, visionary, and a leader has inspired each one of us. Your presence today has lent immense prestige to this occasion, and your words have ignited in our young law students a renewed sense of purpose and commitment to justice. We are profoundly grateful to you, sir, for gracing us with your time and wisdom. Thank you, sir. Next, a heartfelt thanks to Advocate Nagaraj Narayanan sir, Director of Kerala Law Academy and member Bar Council of Kerala. Sir, you are the guiding pillar of this institution. Your vision, leadership, and unwavering dedication continue to shape the academic and professional excellence of our college. We sincerely thank you for your engagement and steadfast support. Moving on, a sincere gratitude also to Professor Ankumar K. Sir, Director of Administration, Students and Faculty Affairs. Sir, your constant motivation and dynamic leadership have always been a source of inspiration for both students and faculty. We are grateful for your presence and continued support. Thank you, sir. A special note of gratitude to Professor Harindran K. Sir, Principal, Kerala Law Academy, Law College, whose guidance and commitment remain cornerstone of every initiative of Kerala Law Academy. Thank you, sir, for gracing this occasion. A special note of gratitude goes to Professor Ankumar G. Sir, Vice Principal, the Kerala Law Academy Law College. Your leadership and guidance have always been instrumental in shaping academic and administrative landscape of Kerala Law Academy more profound. We are also deeply grateful to Dr. Ajda Nair Elma, Head of the Law Department, for her dedicated service, mentorship, and contribution to the academic excellence. Our heartfelt thanks to Dr. Dakshina Saraswati Ma'am, Associate Professor and General Secretary of KLA Moot Court Society. Ma'am, your tireless efforts, guidance, and vision have always been pivotal in successful conduct of this event. Next, I would like to thank Dr. Malavika J., Assistant Professor and Chief Coordinator MCS, for her tireless efforts and wise guidance for the smooth running of this competition. We also extend our sincere appreciation to the faculty conveners, Mr. N.K. Shashidaran sir, Mr. Shibu PG sir, Shibin MI sir, and Gayatri Devi GB for your meticulous planning, coordination, and mentorship have also ensured that this competition runs seamlessly. I extend my gratitude to the Kerala Law Academy Moot Court Society team, Ms. Shalini AP and Giridhar V, Joint Secretaries of Kerala MCS, Kerala Law Academy MCS, Nair Swati Bala Saraswati Ma'am, MCS Training Coordinator, Mr. Subin Jaco Matthew, MCS Media Coordinator, Mr. Manu Krishna, MCS Program Coordinator, then Arjun Sunil, Aishwarya Tulasi, BS Prarthana Karma, Gauri CV, Iron Nalsa Cherian, Anandulal SK, S. Nidhi, Jaya Gopika, Adarsh Darshan, Anandan B. These are the general student conveners of this competition. I sincerely appreciate you for your efforts. Your coordination has been central to the smooth conduct of this today's event. Next, I would like to thank the IT team of KLA. Without their meticulous action, this virtual event would be far from reality. Sincere thanks to the IT team also. Finally, a heartfelt thanks to all the participants of the session. Your presence transformed this event to a truly national celebration of advocacy and legal training. As we move forward into the grounds of this competition, may the spirit of learning, fairness, and advocacy continue to guide each one of us. Thank you all once again, and may this competition be a remarkable experience of growth and inspiration for every participant. Thank you all. Thank you.
Thank you so much, Shakti sir, for your warm words and appreciation. As we come close to the inaugural ceremony, we take a moment to express our heartfelt gratitude to all who made this event possible. Our sincere gratitude once again to all our esteemed guests, talented participants, dedicated faculty, and the tireless technical team for making this event possible.
And to our participants, we wish you all the very best. May your preparation, passion, and performance bring out the advocate within you. With that, we have come to the end of the inaugural session of the 6th Kerala Law Academy Trial Advocacy Competition 2025. This is Aishwarya Tulasi and Iron Sacharian signing off. Thank you all for being with us today, and we wish every participant